Hello and welcome to my new video. Today we are going to cover certain queries and uncertainties and my opinion on that with respect to the DPDA Act. While a lot has been already spoken about DPDA, I am not going to repeat but only cover certain queries and questions and uncertainties that we have observed while discussing with our clients. So let's get into the video straight. So the very first thing that most people ask is that when the DPDA Act actually is going to be enforced. While we all know that the draft rule was released in November 2025 and the Data Protection Board enforcement setup was done on November 14, 2025. While it has been already notified, but the reality as of April is that the selection committee and the nomination of the chairperson and the committee members for Data Protection Board is not yet done. While on one side it's not yet done, but the deadline for implementing consent manager, which was originally set up 12 months from the notification, which means that it's still November 14, 2026. While it may look that it is still 6 months away, but we have to understand that 6 months have already passed, and hence the organizations need to start to look at all of their products and services that they offer, and in those products and services, what kind of PII data they take, and then implement consent management, and it is going to take some time while they execute the engagement. Now, bulk of the other data compliance agreements is 18 months from notification, which means that you still have time of additional 12 months from today, which is April 2026, to comply to. Now, there are quite a few questions that we often feel or get. First of all, people start asking that if they are a small organization, say a tech company with 10, 20,000 people, or a tuition company, which is having PII data of their children or subscribers, do they also need to implement the DPDA? The answer is that yes, it is applicable to all. While they may not be a significant data fiduciary, but it is applicable to everyone. And there are cheaper and easier way to do compliance, like a consent management, which can work in browser, and government will also provide certain tools and platform to do that. The second question is that what if we have existing data practices and how they will be aligned to the new requirements? So the answer is that yes, if you are already having a PII data of your customers, you still need to give them the notification. Now, how we will give the notification and where there will be an action item that is being asked from the people is a different game, and we are going to discuss that later. And then there are certain legacy consent mechanisms. For example, you generally used to click one checkbox and then every consent was supposed to be doomed. But now that is not there because the consent is to be explicit, which we'll discuss later. So that's the first part of it, wherein people are worried about size and scale of the organizations who want to comply and when actually the compliance will happen. So the compliance for the consent manager will happen within 12 months, and then the bulk of the other compliances are due within 18 months. The second is that what exactly constitutes a valid consent and how must it be obtained? So we all know that a valid consent means that it is free and conditional. You have to, or the consumer has to give the consent which is required for legitimate processing of the services that he is subscribing to. But anything else has to be very, very explicit. It has to be specific, which means it has to be purpose driven and it cannot be bundled for multiple rules. And then the consent has to be very clear in a sense that is easily understandable by the end user. And then they are giving the consent which is explicit, and it has to be unambiguous, which means it should have explicit affirmative action required and not a kind of pre-tick check boxes. And last is that it is revocable, which means that you have an authority to go and revoke your consent as and when required. When we say ambiguous and implications, what does it mean? It means that if you are processing the data for a valid purpose, say for example, opening a bank account or giving access to certain free content, other than those, you cannot process that PII data anywhere, which means you cannot use it to do personalization of the services. You cannot use it with AI and analytics because it's completely optional. It can be used for marketing purposes, or it cannot be shared with a third party for upselling or cross-selling any product or services. And if there is any pre-existing consent, then for all that historical consent or the data that you have to give the notification and re-seek the consent. And the consent has to be again very, very explicit. And if there are 5 consent you are seeking, then it has to have 5 different statements, and then the person has to click really each of them. Now, the key question comes is that what happens to a user experience versus what the person will give consent to. Like most people might choose to give only the consent for the data that has to be used for a legitimate purpose. And generally, people might uncheck the boxes to share with third parties or say give personalization of services or give any offers and discounts, etc. But what we have seen is that practically over a period of time, when you go to a particular website and if you see that there is no personalization, then eventually the person might allow you to use so that you remember his history. You might want to give him some personalized advice or personalized show videos or offers, so on and so forth. So over a period of time, of course, it tapers out. But yes, still sharing with third parties or using it for advertisements and promotions might get stalled. So that's where we have to balance it out, that where we have the consent fatigue, which means that are we asking and too much of a consent, and then where do you ask this consent? Say for example, if I am accessing certain areas of a website, that might need a consent, maybe 2 or 3, but then there will be certain other areas where I might need some explicit and different consent. So that is how one way by which people might use to bypass the or balance basically the consent fatigue, and then take consent elsewhere too, or when you are visiting the other parts of the site, so that they avoid really asking for too many consents and you really selecting ones. But then if I'm asking periodically, maybe you might choose more consent and you end up giving more consent so that I can offer you personalized services and advertisements. Now, the third question is that are there any data localization requirements? So this question is often asked specifically from multinational companies. Some of the companies are European, they already are GDPR compliant, and then they ask that if I am offering this service and I have a relatively say shorter or smaller footprint in India, then do I need to put servers here? Do I need to have the data of customers of Indians here in India itself? So the first thing is that currently there is no mandatory data localization requirements, and the cross-border transfers are also permitted by default. Well, you can also use global cloud infrastructure. Now, whether it will be subject to future restrictions is a different thing. But then there are certain uncertainties too, because the law says that if there are blacklist countries, then you cannot transfer data in those countries, but currently the list is not known. Maybe the government might come up in future and publish certain list, and then those will be restricted. Second is also that it says that there are certain set of categories specifically for significant data fiduciary to keep that data in India. But again, it is not very clearly specified that first of all, the who constitute really a significant data fiduciary. We are expecting that anyone who has 100,000 or say million PI records might be significant data fiduciary, and that means that all of your ad tech companies and large consumer tech companies or health tech companies and hospitals or say the big 6-7 global firms which we often use like YouTube's of the world will be covering under that. And nevertheless, to say that banks, insurance companies, they definitely will become a significant data fiduciary. And then there is also an adequacy regime, which means that in GDPR, if you look at it, it says that there is an adequacy decision in GDPR, while for India currently that framework is unclear. I think as we progress, it will come up. And obviously, there will be certain strategic implications of this. For example, multinational companies might consider establishing a data center in India if they are going to be significant data fiduciary. Otherwise, they have to change their architectures in such a way that a certain set of data always remains in India, while there are certain sets of data that they can take it global. But that's quite complex data architectures. And if we are providing services, say using global cloud or data centers elsewhere, maybe we might have to sign the contracts which has certain flexibility in terms of potential data localization mandates that might come across. Now, the fourth question is often asked is that what are the penalties for non-compliance and how they are calculated? I think whether it's cumulative or it is per incident, well, it is not clear because the penalties might range from 10,000 rupees to almost 250 crores. Just like we saw that if you fail to manage the consent, the penalties are going to be like 50 crores. But say, for example, there is a company with a revenue of 100 crores and profitability of 10 crores, then say an tech company, and they end up getting compromised and lose 250,000 user data, which includes PI, then how are you going to judge and put the penalty? It can be on many things, but one of the most important part of the penalty is the intent, which means that did we inform on a timely basis? Were the baseline minimum controls that were required, say for example, a detection mechanism, so certain preventive controls or then security testing or having encryption for PII data, etc., was implemented or not? So if they itself are not there, which means that we have not put any adequate controls, we failed to inform, we tried not to inform, say within 72 hours of timelines, and trying to cover up and did not have any detection mechanisms, and we came to know only when the data was disclosed on public forums, etc., then the penalties can be on the much higher side. So of course, for a small company with a profitability of 10 crores, you cannot put a penalty, which will be existential in nature, but it will be significant, which means to say that it might be a significant part of the profit. So why size and scale matters, but what matters is intent. Second is that reasonable security safeguards that need to be implemented are not there. Now, it's another question that people might ask, that what do you mean by a reasonable security safeguard? So you can have a risk-based controls, and then you can have those security controls put in place, and any typical, IT security consultancy firm can do it for you, where you do the DPDPA or impact assessment, and then basis the risk, you identify and implement controls. But a set of baseline security controls is obviously expected across size of any reasonable size companies. Will there be a grace period to comply or explain? Currently, we do not know. This is an ambiguity. Whether there will be any grace period, there will be audit mandatory from any external panel vendor to ensure that everybody complies to DPDA. How do we know if there are companies who are non-compliant? Is it self-attestation or certification? Currently, we do not know this part yet, whether there will be a third party who will be auditing. Is it self-assessment, or there will be an empanel by the board and then eventually we have to submit an audit report? Or for listed company, it will just be a set of certain assurance mechanisms that people might need to give, or maybe for significant data fiduciary, you might have a assessment, either a self-assessment or a third party that will be required. And then they will definitely ensure that the reasonable safeguards are implemented in terms of controls. Don't forget to like, share, and subscribe, and also press the bell icon to stay notified of all the future released videos. See you in the next one. Thank you.